Hey there, Legal Tea listeners. This is your host, Jenny Roselle. Welcome back for another Legal Tea episode today, episode 110. Today's topic is a current trend, and on this type of episode, we dive into something going on in the current time, or that I've stumbled across on the news or social media, or in this case, Netflix, that is pertinent to my little estate and elder law world. Today's episode is inspired by a recent show that I watched on Netflix, or maybe it was Prime Video. I think it was Prime Video. Nonetheless, it's called The Summer I Turned Pretty. Now, transparently, the show is a little young for me, but sometimes I don't mind watching shows that really don't require me to think. You ever feel like that? That I can just kind of sit there and just mindlessly watch. My brain is always going a million miles per hour and at 100% most days, evenings, hours, and minutes. I just have one of those brains that can't stop. So sometimes I will watch things that just allow me to sit there and not require much thinking. That's this show for me. It's a cute show, but it just doesn't require that much thought. Though I should say before I go on that if you are in the middle of watching this show, there will be a few little spoilers in this episode. So don't get mad at me if you keep listening and if I end up spoiling something that you haven't seen. Anyway, so I just finished season 2 of the show, The Summer I Turned Pretty. In season 1, there's a lady that has cancer, and her 2 boys, of course, are really emotionally struggling with learning about the diagnosis and watching their mother battle it. Then, in season 2, we learn that the mom has actually passed away. Now, you remember that I watched this to not really think, right? Well, I was watching it recently, and in the middle of one of the episodes, one of her sons talks about how they got their inheritance in trust and how their father is the trustee of their trust, aka he's the one holding the power, holding the purse strings maybe. Immediately I was like, well, of course they drop a trust and estate reference in the show that I'm trying to watch to slow my brain down. So here's the quick backstory, the scoop, and really why I'm going to talk about this today on this Legal Tea episode. The whole premise of the show is that there are 2 moms that are absolutely best friends. One of the moms is the one I'm talking about with the 2 sons, and the other mom has 2 children as well, but she has 1 girl and 1 boy. The 2 moms are practically like sisters, and the 4 children are like practically siblings. They're best friends. And every summer, all of them head to a beach house that is owned by the mom that has cancer. And over many, many years, they develop lifelong memories and super deep bonds with one another. Well, after the mom with cancer passes away, the show shares that it turns out that the mom owned this dearly loved beach house with her sister, and her sister wants to sell the house. Now, as we've talked about here, as we've talked about on here before, owning something jointly often does not go through someone's will or trust. It goes to the joint owner. So the beach house goes to the sister who, like I just said, now wants to sell the house that holds so many memories for these kids. The 2 sons of the mom that passed away start talking about how they can save this house, how to keep the house to really keep the memories going. Which that sounds all fine and dandy, except you remember how I described the show as like a young show? Well, it's because these 2 boys are really young. Like one just graduated high school and the other one's in college. So it's a bit, dare I say, kind of delusional to expect that these 2 young boys come up with the financial means to buy a beach house when they don't even have their own personal residences. So that's when, in whatever episode it was, one of them brings up the trust that holds their inheritance. And basically, their father, who is the trustee, declines to empty it out to buy the beach house. And that, of course, goes over like a lead balloon because, in young people maturity style, but Dad, they want to keep the house. So as a cheesy show would have it, one of the sons sees a newspaper headline about someone's trust being terminated, and now they want to know, well, can they do that too? Can they terminate their trust so that they can have their hands on the money to buy this beach house? So fast forward through the show, they choose not to push forward with, seeking court intervention to terminate their trust. But nonetheless, it made me think that would be kind of a fun topic to talk about on Legal Tea. So since the show, The Summer I Turned Pretty, is new, I'm counting it as a current trends episode, so just bear with me. I'm kind of stretching this type of topic. So let's talk about it. Now, what are ways to wiggle your way out of a trust? First, I would look at the actual trust document to see two things. First, who is the trustee? That is, who's holding the keys to the car, so to speak. And second, what does the trust document allow? Does the trust allow the trustee to wipe it out and liquidate the trust for the beneficiaries? Does the trust give the beneficiaries any authority to have a say in distributions? Does the trust give anyone the authority to terminate the trust? Now, in my experience, when this whole can I get out of this trust question comes into play, and I have had actual, real life clients come to me with sort of similar situations where they're trying to get out of a trust. And they're usually coming to me because usually the trust document does not expressly allow it. When this is landed on my plate, it's usually because the trustee is unwilling to cash in the trust. And hey, maybe that's a good thing. Like here on The Summer I Turned Pretty, was it a really, a good use of the trust money for these sons who are young to buy a beach house? And or two, the other reason, this kind of thing lands on my plate sometimes is that the trust is spelled out so specifically that it doesn't give the trustee to do much. So for example, I actually have a case sitting on my desk right now where a beneficiary is entitled to $100,000 a year from the trust he inherited from his parents. And he asked me if he's entitled to anything more than the $100,000 a year. And he's not. The trust states it's $100,000 a year, period, end of story, until it runs out. If the trust document does not give you any wiggle room, usually the one recourse at that point is to get the court involved, unfortunately, and request that the court or the judge terminate the trust. There are a few options along these lines that, that we should just go over them quickly just to keep this, nice and informative for you guys. And that way, maybe this applies to you or someone you know now, or you or someone you know in the future. And before I start, I should say that these are coming from the Indiana Code. So these are very Indiana specific, though I have mentioned this sort of thing here on Legal Tea Podcast before, that I find that many states are fairly similar-ish in these kind of things. So this is, if this is something like really pertinent or relevant for you, just be sure to speak with a licensed estate attorney in your state to ensure that you're working with accurate information. Okay. Let's start with, there is a part of the code that allows for termination of a trust with less than $75,000 inside the trust. Here in Indiana, there's a law that states that if the total value of the trust is less than $75,000, and if the trustee concludes that the value of the trust is insufficient to justify the costs of administration, and the trustee notifies the beneficiaries, the trustee can actually push forward with terminating the trust and distributing the assets as the trust dictates. And that's like not through the court, like that just is allowed under the law. It is important to know that it does say at the beginning of this provision, this section in the code, that it says, unless the terms of the trust provide otherwise, which means that if the trust document has a section on this very thing, the words in the document override this. So I've seen, some trust documents will say, this can only happen if the trust has less than $25,000. Or like earlier when I was talking about the beneficiary that's entitled to just $100,000 a year, period, end of story, those provisions in the trust would override what this statute allows. Does that make sense? So this option can be done by the trustee without court involvement. If necessary, though, the court could be involved in this. Say, for example, the trustee wanted to terminate the trust and say the trust was under $75,000, but maybe the beneficiaries disagreed. Then the trustee could ask the court to determine that continuing on with the administration is just not in the best interest of the beneficiaries. I could see that happening. Rarely, very infrequently, but I could see that happening. But it is a nice segue to the next way to terminate a trust, which is termination of trust by getting the court involved. So a trust can also be terminated by the court or the judge if the purpose of the trust has been fulfilled, or continuing on with the trust administration would be illegal, impossible, impracticable, wasteful, or impair the administration. Now that's a lot to unpack. I get that. But basically, to me, I would say if you can prove with data and hard facts why this trust should not continue, then you have a fighting chance. Since the court is involved, it would 100% be recommended by me that an attorney be involved to help you craft this type of argument. Terminating a trust through the court is probably more likely and the more popular solution of all the solutions and options that we're going to talk about today. Of the cases I have worked on when we are asking the court to terminate a trust, it's because either the trust exceeds that $75,000 threshold and that maybe the trustee doesn't want to serve anymore, or the trust doesn't just make sense anymore. For example, back in the day when the estate tax exemption was really low, a lot of people did irrevocable tax planning trusts in case they were to pass away while the estate tax limit was so low. Well, the limit got increased, and it's increased every year really since then, and it's currently $12.92 million per person. So as a married couple, you get 2 of those. So people have these like super complicated irrevocable trusts for, at least in their opinion, just, for really no reason if they're really far below that estate threshold. So sometimes those kind of people want out of those trusts, and in those cases, I have worked on these kind of things. The court has let them out. It was a little bit of a process to get to the finish line, but that's okay. We did it. It just was, nothing comes easy, right? Okay, one super quick final thought on this topic. Another option, another solution possibly on the table is something called decanting a trust. I'm going to do the world's fastest explanation since we're, almost out of time. But there's something called decanting a trust. It's D-E-C as in cat, A-N-T-I-N-G, decanting. Decanting a trust does not involve the court. But basically, there's this specific thing under our Indiana code. Again, I'm not sure about other states too, but probably they have it as well. That it basically allows us to take trust assets and dump them into another trust so long as the provisions are fairly consistent or like the same. This is also something on the table, but just work with someone like me in your state and they'll help you uncover the options. I have decanted a trust for various reasons as well. I've actually used all these options, all these solutions before. So just know that there are options on the table if you are trying to get out of a trust. Alrighty, I hope this topic was kind of different, kind of interesting, inspired by my silly little show that I happened to start watching, The Summer I Turned Pretty. I'm glad my mindless show watching turned out to be fruitful, at least for this podcast, right? Okay, I'm out of time, so let's wrap up this episode. Next week, I'm actually going to take the week off, my friends. It's Labor Day weekend. I'm running a little bit behind. I've got some really cool things going on professionally that I'm involved in. That's kind of put me a little bit behind. So I'm going to use it as a reason, as an opportunity to catch back up. So you will not have an episode next week. I'm so sorry. But the following week's topic, which will come out the week of the September 11th, is back to the estate planning of the rich and famous topic. And on that episode, we're going to do a fun one. We're going to go over what happened estate-wise following the passing of Casey Kasem, who, I should have double-checked how to pronounce his last name. I'll double-check before I do that episode. But it's likely a name that you may not immediately recognize unless you're the biggest Scooby-Doo fan ever. But Casey, he was the voice of Shaggy on the show, on the Scooby-Doo show. Well, he passed away, I think, back in 2014, and some stuff happened in his estate proceeding. It'll be a good one to listen to. So we will dive into that on September 12th. So if you have an opportunity, catch up maybe on, prior episodes or something next week. And then I will talk to you guys on September 12th. And have an awesome Labor Day weekend. Talk to you in a couple weeks and stay well.